Okay, this is the rest of the letter to Commissioner Long that I wasn't able to finish on the Truth Attack Hour radio show for July 3rd. So this is picking up with where we got interrupted at the end of the show, as it ended after just 1 hour. Okay. Well, to make a long story short, the Supreme Court's ruling in Moore last June that income taxes are indirect taxes under Article 1, Section 8, Clause 1, and are not direct taxes under the 16th Amendment at all, exposes completely the extent of the rebellious sedition being perpetrated by the IRS, the U.S. Department of Justice, and the lower federal courts, which sedition and rebellion has been ongoing in those courts and inside the IRS and the DOJ for over 50 years in order to assist the federal government in its decades-long effort to socialize the American people, utilizing the Social Security and welfare programs, all funded by the unconstitutional class legislation of the second plank of the Communist Manifesto, a graduated income tax, used to fund the unconstitutional expansive operations of the federal government's redistribution of wealth under and through its ever-expanding agency bureaucracies into every aspect of our social existence and our daily lives. One should also carefully note that the Supreme Court acted in Moore not to write a new decision, but rather to reaffirm their original decision taken 109 years ago in Bruchaber v. Union Pacific Railroad Company in 1916, which is the exact same case that all of the federal circuit courts of appeals have erroneously invoked to justify the erroneous non-apportioned direct tax holding by reversing over the last 45 years the true holding of the Supreme Court in that Bruchaber case by simply proclaiming, without sight of any specific text from that Bruchaber decision, that the income tax was allegedly determined in that case to be a non-apportioned direct tax under alleged authority of the 16th Amendment without limitation, which of course, as stated, actually worked to completely reverse the true holding of the Supreme Court in that Bruchaber case decision, which held the tax to be indirect, not direct, and under the authority of Article 1, Section 8 of the Constitution, not the 16th Amendment, exactly as all reaffirmed now by the Supreme Court in Moore. Sir, the income tax as currently enforced since World War II is a monstrous constitutional and judicial fraud. And the opinion in the Moore decision taken in June of 2024 clearly exposes that fact by reaffirming the true holding of the Supreme Court in the original Bruchaber decision taken in 1916, i.e., the income tax is an indirect tax under authority of Article 1, Section 8, Clause 1, and is not a non-apportioned direct tax without subjectivity to any constitutional limitation under authority of the 16th Amendment, as erroneously held and enforced in the lower courts for the last 50 years. Actually, since World War II. Sir, I believe that President Trump may be empathetic to this crisis situation now, having himself recently experienced in court some of this judicial impropriety, at best, or absolute corruption of the courts, at worst, and in truth, arising out of this corrupt and prohibited use of judicial legislation by the judges in the federal courts to rewrite both the law, the statutes of the United States Code, and the U.S. Constitution. And thus, the reaffirmation of the Bruchaber decision by the Supreme Court in Moore last June works to establish 109 years now of undisturbed controlling precedent that immediately exposes the monstrous extent of the constitutional fraud that has been perpetrated by the IRS, the DOJ, and the judiciary of the lower federal courts against the American people for the last 50 years in the name of tax only, under color of law, and under the guise and pretense of income tax law enforcement under authority of the 16th Amendment, which tax has been wrongfully and unconstitutionally enforced erroneously by the IRS, the DOJ, and the federal judges of the lower courts against the American people for the last 50 years as a non-apportioned direct tax on their labor and fruits of labor derived from the simple exercise of the citizen's right to work, regardless of the lack of any subjectivity to any indirect impost, duty, or excise tax or taxation, and without application of any constitutional limitation imposed on that alleged new power to tax directly under alleged authority of the 16th Amendment, which is all fatal constitutional error under Moore and Bruce Shaber. Again, according to the Supreme Court in Moore, that direct and unlimited taxing power has never been granted and does not exist as a granted power of the Constitution for the IRS or the federal courts to enforce, because the court held in Moore that income taxes are indirect taxes under authority of Article 1, Section 8, Clause 1, and that it is not a direct tax under the 16th Amendment. They further reaffirmed that all direct taxes must still be apportioned to the states for payment and laid in proportion to the census, as is still constitutionally required under Article 1, Section 2, Clause 3, and Article 1, Section 9, Clause 4 of the Constitution, regardless of the adoption of the 16th Amendment. Therefore, it is categorically impossible for there to have ever been a non-apportioned direct tax on income under the 16th Amendment for the IRS to enforce by any means, lien, levy, or lock-in withholding, or for the DOJ to prosecute civilly or criminally in any U.S. court, or for the courts to adjudicate under any constitutionally granted and conferred subject matter jurisdictional authority, which does not exist neither constitutionally nor statutorily under any authority, neither the 16th Amendment nor any statute. I have attached here to the evidentiary proof of the constitutional fraud that has been perpetrated in the courts, by the courts, your IRS, and the Department of Justice against the American people for the last 50 years. The proof comes in the form of the Moore opinion, excerpt, relevant portions highlighted on pages 5 through 7, and the relevant portions of the IRS's frivolous positions document, which work together to irrefutably provide the proof of the erroneous argument position of the IRS, DOJ, and the federal courts over the last 50 years. The correct argument position asserted by SCOTUS and of the constitutional fraud that's been perpetrated by those federal institutions based on their erroneous advancement and enforcement of that fatally flawed and erroneous argument position of a non-apportioned direct tax on all income under the 16th Amendment. Sir, you and the entire Trump cabinet, including President Trump, need to be fully briefed on the full extent of these matters, because there is a lot more information about this that you need to know, or at least be aware of, before moving forward with advocating for any tax law changes other than preventing the existing income tax law from some sunsetting and expiring and reverting back to the tax rates and tax brackets of 2017 that were in place before the 2018 changes, when the tax legislation President Trump signed went into effect. Sir, you may certainly contact me for more information on this or to arrange for a full briefing in your offices of both yourself and your senior staff if you desire, because I have a lot more supporting evidence and information about this monstrous constitutional fraud that has been perpetrated on America since the end of World War II and the expiration of the victory tax. Sir, if you want to see how extreme and routine the judicial corruption in America has become in the courtroom, I would love to brief you on the case of Paul Kenneth Cromar, criminal case 223 CR-159 and civil case number 217-CV-01223, both in the Federal District Court of Utah, Salt Lake City, where the criminal case is now in the appeal phase in the U.S. 10th Circuit Court of Appeals as appeal number 25-4002, after an unconstitutionally rendered conviction by a jury that was not allowed by the district court judge to be shown the law by the defendant during trial as his defense, in a district court that fatally lacked the subject matter jurisdiction to try either a criminal case in 2023 or a civil case in 2017, where Mr. Cromar's home and property were unconstitutionally foreclosed on over an alleged failure to pay a non-apportioned direct tax on income that does not constitutionally exist to be enforced by the IRS or the courts. I have attached some basic supporting foundational information for you to review, hoping to hear from you soon. Thank you. Sincerely, Thomas Freed. Okay, so if you wanted a copy of that letter, you can email me at tom@irszoom.com. You'd be free to send this to any politician in the country or anyone else you think might be able to use the information to help us expose the fraud and get back to a constitutional taxation, which of course is going to take a complete repeal of the personal income tax. And personally, I think you should repeal the corporate income tax because they don't pay any, they just expense away all the profits. It promotes fraudulent accounting and has allowed the entire burden of the tax system to be shifted off of the backs of the corporate subjects upon which it was intended to be applied and shifted over onto the backs of labor, to which it has no constitutional application and who was never intended to be the subject of the tax. Because there's no profit in an hour of labor. It's an equal exchange of value for value, dollars for time, as the time is valued to be provided by the person providing it, which of course could be someone like Alan Dershowitz making $5,000 an hour, or it could be someone who can't speak English making $8.25 an hour. But either way, there's no profit. It's value for value. The one is $8 because that's what you get out of it. The other is $5,000 because that's what it's worth. And there's no profit in either. And there was never intended to be a tax on the labor of American people. The tax is intended to be a tax on corporate profits and earnings of foreign persons, licensed persons. Never intended to be a direct tax on the labor of the American people without application by impost, duty, or excise. No such power is granted. No such power exists. And as I've repeatedly demonstrated and proven, none of the money taken, neither from your paycheck nor that which is sent in on April 15th, none of that money ever goes into the U.S. Treasury. It all goes around the Treasury to the Federal Reserve Bank because it's not a system of taxation. It's a system of peonage involuntary debt service, peonage-like involuntary debt service, where you're reduced to the role of a peon whose only purpose is to work so the master can take whatever he needs to pay his own debts to the party he's accrued them to. You know, his whores, his court, his gambling buddies, his munition suppliers, and of course, the king, who he owes his debts to. And they've just taken that peonage plantation system out of the 11th century and turned it into today's quote unquote tax system. The people exist to be controlled by the overseers who collect the fruits of labor to pay over to the master so he can pay the Federal Reserve Bank. The master on the hill is now Congress, and the king is the Federal Reserve Bank, where all the money goes. It's not a system of taxation. And as a result of the American people being willing to have their labor collateralized to service the $37 trillion in debt, the Federal Reserve Bank kindly lends you another $5 trillion to operate this year. And pretty soon, the paper notes are worthless, and inflation destroys the ability of the population to have any quality of life other than impoverishment. So, if you want to help me expose the system and terminate it, get a copy of the letter and send it to every politician you can, telling them to go get educated at taxfreedom.com and educate their people, because apparently the government doesn't want to admit this has happened. They'd rather argue Roe v. Wade still calls for federal abortions, Chevron still allows regulatory deference, and affirmative action is perfectly okay because they're in rebellion against the Supreme Court. They have been since 1942, and it's not going to go away. And it's this, or the rather, the liberal Supreme Court of the Roosevelt era that survived into the 50s and early 60s that gave you all these bad, liberal, unconstitutional decisions that have been used to divide the American people, fund the bureaucracies through regulatory deference and the income tax, or rather increase the power of the regulatory bureaucracies through the regulatory deference of Chevron, which lets them write their own law, which is what they've done with the income tax. There's no statute that makes you liable. That comes out of regulatory deference, where they wrote a regulation that says you're liable for the tax because it's imposed. But it's a rate of tax that's imposed by Section 1 on taxable income. How are you liable for a rate of tax on taxable income without an assessment of the tax? And of course, you're not. And that's why the statute doesn't make you liable. It's all a constitutional fraud. The bureaucrats have made it all up. The direct tax, the non-apportioned tax, the liability for tax. It's all made up. It's all constitutional fraud. And of course, the work at taxfreedom.com exposes all of that. The letters at irszoom.com argue all of that to the IRS when necessary and to the DOJ when necessary. And this is where your best resource is for help in answering the IRS or the DOJ. Because the attorneys are either asleep or just blind and unable to read the English language and apply it as written by the Supreme Court in the Moore et Ux, the United States decision, along with Brushaber, Baltic Mining, Stewart Machine in 1937. The Supreme Court's been 100% consistent on everything. It's just been silent since Stewart Machine. And it's allowed the bureaucrats and the lower courts to get away with this fraud. So I'm going to post the letter at taxfreedom.com. You can get a copy either by downloading it, I suppose, or by sending me an email at tom@irszoom.com, and I will send you back a copy in Word doc so you can edit it as appropriate for you to send to whoever you want to send it to, a state representative, because all the state tax has been piggybacked off of the federal unconstitutional interpretation as a direct tax. So all of the state income taxes fall when this direct tax finally falls as well. And fall it well, it will, because the writing's on the wall. The guillotine blade has been released. What the court wrote and more, they can't take it back. It's a proper and correct review of the Constitution's granted taxing powers, which are all subject to some limitation. If they're indirect, they must be uniform. If it's direct, it must be apportioned to the states and laid in proportion. There is no such thing as a non-apportioned direct tax, which is what they have been enforcing on you for over 75 years. The fraud is exposed. The emperor wears no clothes. He's standing naked on the stage like a fool and an idiot, trying to tell you you can't really see what he's swinging. It's all a lie. It's all a fraud. And America needs to get ahead of it before the bankers close out the operation. Because that's where we're going. At 37 trillion in debt. Aimed higher all the time. That's where we're going.